Okay, folks, welcome to Secured Transactions, or what I like to call the boring one. Um, kind of kidding. So what is a secured transactions? Frequently, when you buy a large item, like let's say a car, you finance the car. You don't pay for it all outright in cash, but you finance it. When that happens, there's actually two transactions going on. There's a contract for you and the car dealership for the purchase of the car, and then there's a separate contract between you and the financing company, which is the financing of the car. And the financing of the car is the secured transaction. So a secured transaction is an agreement between a borrower and a lender where the borrower provides collateral, an asset, to secure the loan. If the borrower defaults, the lender has a legal right to satisfy the debt. So typically what happens is the collateral of the loan is whatever the item is that you've purchased. So when I buy a house and I get a mortgage, the collateral for my mortgage is the house. The collateral for my car loan is the car. So I'm saying, I want to buy this car. I'm going to give you a piece of the car in exchange for you providing me the money to pay the car off. So some examples, like I said, car loan, the vehicle is collateral, mortgages, the house is collateral. A lot of times in business loans are granted based on inventory or equipment that serves as collateral. Maybe your tractor, maybe your 10,000 cases of water bottles, whatever it might be. So some key components of secured transactions. Well, first of all, you need the borrower, also known as the debtor. This is the person who is receiving the loan and generally making the purchase. The lender, or also known as the secured party, is the entity that's providing the loan. The collateral is the asset pledged to secure the loan. And then the security interest is the legal claim that the lender holds on the collateral. More about that in a minute. In order to create a secured transaction, we have a loan agreement where the borrower and the lender agree on some kind of loan terms. The borrower then pledges the asset as collateral for the loan. The lender files a financing statement to make the loan interest public or putting the world on notice. Again, more about that later. And if the borrower fails to repay, the lender can seize the collateral in what's called a default process. So what are the benefits of secured transactions? Well, for lenders, there is reduced risk in providing the loan because they have an interest in the collateral. The collateral for my car, really? The title belongs to the lender until I pay the car off. So really, the car is theirs until I finish making all the payments. I have an interest in the car, but it's really theirs. And for borrowers, it gives borrowers access to larger loans or better interest rates through reduced lender risk because the lender has the interest in the collateral. So where does the law that governs secure transactions come from? Well, it comes from Article 9 of the UCC, which governs secured interest in personal property. And that applies to a transaction that creates a security interest in personal property, fixtures, or by contract. Fixtures are generally items that are attached to a piece of property. So for example, your toilet in your house is a fixture. Your hot water heater is a fixture. Anything attached to the property is a fixture. Agricultural lien, sale of accounts, chattel paper, payment intangibles or promissory notes, and a consignment. There are some interesting definitions that relate to secured transactions, and I will post a separate listing of all of the definitions that relate to secured transactions. I don't want to include them in the lecture because there's a lot of them. When you gain a security interest in a piece of collateral, that's referred to as attachment. The attachment is the process that makes a security interest enforceable against a debtor. I attach my car loan by giving the lender the title until I pay it off, okay? And attachment occurs when a secured party gains rights in the collateral provided by the borrower. So they're gaining the rights provided by me by letting them have the title until I pay it off. So the requirements for a security interest to attach, you have to have a lender that gives something of value, such as a loan. The debtor has to own or have rights in the collateral that's being used to secure the loan. So if a lender gives me a loan for a car that's not going to be mine, I'm not really buying the car. I guess I'm just like renting the car. So I have to have some kind of ownership value in the collateral as well. We each have ownership in the collateral, so to speak. We have to have some kind of record that demonstrates that the lender has interest in the collateral. The security agreement outlines the collateral and the terms of the loan. So what is the process for attachment? First of all, we have the loan agreement, signed loan agreement. Each side signs on the loan terms, and the debtor has to pledge the collateral. The lender has to provide the loan or the credit to the debtor. There has to be a security agreement or a written agreement. The debtor holds rights to the collateral and the security interest. Once all of those conditions are met, then the security interest attaches, meaning that the lender has rights in the collateral. So just because someone has given me a loan and they have attached their interest to the loan doesn't mean that they might be the first person to be able to repossess the collateral if I default. You are the first person to be able to possess the collateral through a process known as perfection. And you perfect through a variety of ways. You can perfect through the filing of a financing statement. You can do this through the State of California website. You can also do it at the local courthouse. Generally lasts for about 5 years, and then you have to renew it if the loan is for longer than that period. You can possess through taking possession of the collateral. So with my car loan, they take possession of my title. And with intangible assets like securities, the lender can perfect an interest through gaining control of the asset. If I am, for example, buying options on a margin, the account that I have with the broker might serve as the perfection method because they have control and the ability to repossess my account or repossess the assets in my account, the digital assets, so to speak. So control is the third method of protection. So the process of perfection, first of all, you have to attach to the security interest. We already talked about what attachment is. File the financing statement. And filing the financing statement puts the public on notice that you have a legal claim to the collateral in case of default. And once you have perfected, you take priority over all of the other creditors who might also have an interest in that piece of collateral. So some examples of perfecting. Vehicle loan, you would file a financing statement. With a business loan, you might perfect a claim through also filing a financing statement or taking possession of the collateral. And then financial securities are perfected through control. I might have an account with Charles Schwab, but Charles Schwab also has the ability to go in and seize my account if I borrow to invest and I don't pay it back. So why does perfection matter? Perfection matters because it puts the world on notice that the lender has priority over other creditors in case of the debtor's bankruptcy or if there are other competing claims, if somebody else might have a claim on the collateral as well. It protects the lender's right to claim the collateral when the debtor defaults. So it helps, in essence, to make the process predictable if something should happen. So if we have multiple creditors who might have interest in the same piece of collateral, we need to understand the priority to ensure that we know what position we're in and really what our level of risk is with respect to that piece of collateral. Typically, we have 3 types of creditors. We have secured creditors, and a secured creditor is a creditor who is the loan is secured through a piece of collateral. Mortgage, car, car loan. The collateral is the house or the car. Unsecured creditors are creditors who have an interest, but the interest is not secured through the possession of any collateral. Your credit cards, for example, you use your credit card to go and buy things. Your credit card company doesn't take possession of your Amazon sweatpants until you pay the bill off. They're an unsecured creditor. So you know and they know that you owe them money, but there's no collateral for them to come and take possession of in case of your bankruptcy or default. And then we also have what are called judgment creditors who've won a legal judgment against the debtor but have not necessarily secured the collateral. Maybe I have taken someone to small claims court over a car and I have won that claim. So I'm holding on to the judgment, but the judgment has not been paid yet. So what determines creditor priority? First of all, if you have a perfected security interest, you generally have priority over all other creditors. Generally, the rule is the first to file or the first to perfect has the highest priority. A PMSI is a claim that allows a lender to repossess property that was financed with its loan or to demand payment in cash if a borrower defaults. Our car loan in many cases is also a PMSI. PMSI creditors have a superior claim over other secured creditors if they perfect within a specified time frame. And that time frame differs depending on the type of goods that we are talking about. Priority rules in a secured transaction if the borrower defaults. First priority is perfected secured creditors. If you have a secured transaction that's perfected, you generally get the collateral. Second priority or a super priority goes to PMSIs. PMSIs can jump ahead of previously perfected creditors if they perfect quickly after the debtor acquires the collateral. Lower priority is unperfected secured creditors. So secured creditors who fail to perfect, maybe they have the security, but they haven't done any, they've attached, but they haven't perfected. And then the last priority goes to unsecured creditors, so those credit card holders or their credit card companies. And then judgment creditors have their own priority, but they generally fall below secured creditors who have perfected their interest. Collecting on a judgment generally can tend to be a difficult process, and it tends to be more specialized. So some special considerations. Competing claims. If two or more secured creditors have a claim in the same collateral, the order of perfection determines priority. The person who perfected first has priority. In bankruptcy cases, secured creditors are paid from the collateral before unsecured creditors receive any distribution. An unsecured creditor is just that, unsecured. They generally get a higher interest rate because of the risk involved in loaning money with no collateral. Sometimes we have what's called an after acquired property clause. So you have a secured creditor, and then there's a clause in the agreement that says that they can also claim new property acquired by the debtor after the security interest is created. So this might happen like with inventory, for example. I might be securing my loan with my 10,000 bottles of water inventory. Well, those 10,000 water bottles are going to be sold. And so that lot that I purchased might be gone and there might be a new lot. The secured creditor still maintains an interest in that after acquired property, even though the initial property that they financed is now gone, sold, whatever. So what happens when a debtor defaults? Generally, the secured creditor has specific rights under the terms of the security agreement and applicable law. Generally, that's Article 9 of the UCC. So what can the creditor do? Well, first of all, secured creditors have the right to go and repossess the collateral. Repossession can occur without a court order as long as it's done without a breach of the peace, which means no force, no unlawful entry. You can't break into somebody's garage to repossess their car. And generally, if you're repossessing somebody's car, you're going to do it in the middle of the night because you don't want to breach the peace. You want to do it when everybody's sleeping and nobody gets upset until they wake up and see their car's gone. The right to lease, sell, or dispose of collateral. After repossession, the creditor has the right to do basically however dispose of the collateral however they want in order to recover the unpaid debt. They also have the right to keep the collateral to satisfy the debt. However, if the value of the collateral is higher than what's owed on the debt, they do have to reimburse the debtor for the excess value of the collateral. If the collateral is not enough to satisfy the debt, if you have a car that's worth $5,000, but the loan is for $7,500, and they come and they repossess the car, they can also sue you. So they can have your car, and then they can also sue you for the balance between what the car is worth and what you owe. When the creditor repossesses the collateral, they have to provide the debtor or any other interested parties, such as other secured creditors, with a notice of disposition. If they've repossessed your car and you want your car back, they have to tell you when and where they are selling your car so that you have the right to go and try to get it back. And it has to be, the sale or disposition has to be conducted in a commercially reasonable manner, meaning it has to be fair and in line with market standards to avoid undervaluing the collateral. I cannot repossess your car and then sell it to one of my good friends for less than the value of the car and then sue you for the balance. I have to, if I am repossessing a $10,000 car that is worth $10,000, I have to sell it for $10,000. Once the collateral has been repossessed and sold, the proceeds of the sale are applied in a specific order. First of all, they have to cover the expenses related to repossessing and selling the collateral. Second, pay off the debt of the creditor. Any surplus goes to junior creditors with subordinate claims. And then if there are any leftover funds from that, they get returned to the debtor. And again, if the proceeds from the repossessed collateral are insufficient to cover the entire debt, the creditor can pursue what's called a deficiency judgment against the debtor for the remaining balance. So we talked about repossession can't break the peace. Junior creditors have to be notified about the disposition and have a chance to claim any leftover funds from the sale. And before the sale, the debtor has a right to redeem the collateral by paying off the full debt, including any additional costs that incurred due to the default. Okay, sometimes when we have a secured transaction, we might have a third party involved in the transaction who guarantees performance of a debtor's obligation to a creditor. If the debtor defaults, that person, known as the surety, is responsible for fulfilling the obligation, often by paying the debt or performing the debtor's duties. Elements of suretyship. So we have the party who owes the obligation or the debt. We have the guarantor or the surety, who is the third party who's going to step in and fulfill the debtor's obligation if the debtor defaults. And then we have the creditor, who is the party to whom the obligation is owed. Usually it's the lender or the secured party. So first of all, we have a suretyship agreement. The surety agrees to be the legally responsible party for the debtor's obligation. Typically, it's outlined in a suretyship agreement. This can be in business loans, contracts, or other secured items. When the debtor defaults, or if the debtor defaults, I shouldn't say when, I should say if the debtor defaults, the creditor can demand payment from the surety. If you think about like co-signing a loan or a loan guarantor, when someone co-signs a loan for you and you default, the bank can go after the co-signer. The surety performs or steps in and pays the debt. And then after the surety fulfills the obligation, the surety has the right to go and seek reimbursement from the debtor for the amount that was paid on their. 3 types of surety. A contract of suretyship, where you have a formal contract where a surety guarantees to step in. A cosigner or a guarantor who acts as the surety to be responsible for the default if a default happens. And then in construction or service bonds, surety can take the form of what's called a performance bond, where the surety agrees that a project is going to be completed in accordance with a contract. What are the rights and obligations of the surety? The surety has to be informed if the debtor defaults, or if any changes in the obligation occur so that they know to step in. The surety has a right to reimbursement, so they have the right to demand reimbursement from the debtor. The surety has a right to demand that the debtor take action to fulfill the obligation before the surety is called upon to pay. And after paying the debt, the surety gains the same rights as the creditor and can pursue claims against the debtor. So the surety can go and get their money back. They have the right to go and get their money back. So what are the defenses of a surety when a lender when a lender pursues them for payment? The release of the principal, that the principal has been released from the contract, and so therefore the surety should be too. Modification of the contract, a creditor's failure to perfect, surety is released via the statute of frauds. The creditor's failure to inform the surety of material facts within the creditor's knowledge affecting the debtor's ability to perform. For example, that the debtor has defaulted several times before and the creditor didn't tell the surety that. And then the surety also has all of the general defenses that folks have when defending themselves from breach of contract. So what are the defenses of the debtor? Not many. Death or incapacity, bankruptcy. Defenses of both the debtor and the security: material breach by the creditor, lack of mutual assent, or failure of consideration, so mutual assent, lack of agreement, failure of the consideration, creditor's fraud, duress, or misrepresentation, impossibility or illegality of performance. So again, these are contract defenses. Material or fraudulent alteration of the contract, or the statute of limitations. The defenses of the surety only: fraud or duress by the creditor on the surety, illegality of the suretyship contract, the surety's incapacity, failure of consideration. So again, these are all contract defenses. The statute of frauds, acts of the creditor or debtor materially affecting the surety's obligations. So refusal by the creditor to accept lender of performance, release of the principal debtor without the surety's consent, release of the surety, release, surrender, destruction, or impairment of the collateral, extension of time on the principal debtor's obligation, and modification of debtor's duty, place, amount, or manner of debtor's obligations. Whew, that was a lot. But we have reached the end of the lecture. So that for you was secured transactions.